Hi, everybody. Today's Fact in 5 video is all about inherited IRAs in the Secure Act. I may go over the 5-minute timeline by just a little bit, so I'm not sure if we can technically call this one a Facts in 5, but I'll still try to get through the information as quickly and concisely as possible. So to dive right in, qualified retirement accounts. This is what the Secure Act applies to. So I know my title slide, I said inherited IRAs because IRA can be kind of just a blanket term that applies to all qualified retirement accounts. And qualified retirement accounts are those types of accounts that are funded with pre-income tax dollars. So amounts that you've never paid income taxes on. With the deal being that while you're working, these funds continue to sit in the account and grow. You're continuing to add more funds to the account, and that when you retire and start withdrawing funds from the account, that's when the income taxes are paid. So that's what qualified retirement accounts are. And some common examples are 401ks, 403bs, IRAs themselves, but again, not uncommon for somebody just to refer to the entire category of qualified retirement accounts as IRAs. With IRAs, you also want to be wary of the RMDs. So the RMD is what's known as a required minimum distribution. This is the amount that is required to be withdrawn from these accounts annually, either during the plan holder's lifetime or the account holder's lifetime after they retire, or by the beneficiaries who inherit these accounts after the initial account holder's death. So now what is the Secure Act? The Secure Act is a group of federal laws that went into place originally in January of 2020. They were subsequently amended under the Secure Act 2.0, which went into effect on December of 2022. And the Secure Act did a bunch of different things, but primarily for estate planning purposes, the biggest piece we were concerned with is that the Secure Act changed all the rules in terms of what types of distributions were required to be made from IRAs when they were inherited by beneficiaries. So the Secure Act only applies to IRAs inherited after January of 2020. So if you inherited an IRA prior to that date, the old rules still apply. And I'll get into a little bit of what I mean by what those old rules are. And generally speaking, the Secure Act created 3 classes of beneficiaries. And depending on which class of beneficiary you fall in, that's going to determine when distributions are going to have to be made from those inherited IRAs. And the 3 classes of beneficiaries that the Secure Act created were eligible designated beneficiaries, or non-designated beneficiaries. An eligible designated beneficiary is someone who is going to be entitled to receive stretch IRA treatment, which means they get to take RMDs from these inherited IRAs the same way the account holder did during their lifetime before they passed, which means they get to take a small amount each year based off of their life expectancy. An eligible designated beneficiary is either a spouse, a minor child, a chronically ill beneficiary, a permanently disabled beneficiary, or any other individual beneficiary that's not more than 10 years younger than the original account holder. The second class of designated beneficiaries is kind of any other individual person that doesn't fall into those categories that were just listed under eligible designated beneficiary. So a nephew, a grandchild, a child, kind of anyone else that doesn't fall under one of those exceptions. And in that case, those designated beneficiaries only get to take advantage of what's called the 10-year rule, which means the entire inherited IRA has to be withdrawn within 10 years of them inheriting the account. Non-designated beneficiaries, which is any non-individual that's named as a beneficiary. So an estate, a business entity like an LLC, certain types of trusts, basically, again, non-persons that inherited an IRA. And in that case, those beneficiaries only get the 5-year rule. So it's kind of even less advantageous. This one applies a lot of times when people just fail to make a beneficiary designation on an account. So if you pass away and you never named a beneficiary for your IRA, and the default is that it passes to your estate, now all of a sudden it's the 5-year rule, for example, that would apply. So RMDs and inherited IRAs. So as I mentioned, with the eligible designated beneficiaries, they get stretch IRA treatment, which means those RMDs, those amounts that they're required to take out each year, are going to be based off of their life expectancy. The IRS has created numerous tables that say based off of what age you currently are, this is how long we expect you to live. So based off of that estimation, this is how much you have to withdraw in any given year. So as you get older, those distributions are going to change because your life expectancy changes. So it's not necessarily going to be the same amount every year. But again, if you're an eligible designated beneficiary, you are just taking those RMDs each year over the course of your lifetime. You can take more, but at a bare minimum, you have to at least take out those RMDs. Under the 10-year rule, RMDs are going to have to be taken only for certain classes of folks. So for example, if the deceased account holder died before they reached age 72, in that case, the beneficiary is not required to take RMDs so long as just the full account is withdrawn by the end of the 10th year. So they can take some every year still anyways. They can take it all out in year 1. They can wait and take it all out in year 10. It's up to them so long as it's all taken out within 10 years. If the deceased account holder died after reaching age 72, which essentially means the original account holder had already started taking those RMDs during their lifetime, in that case, the beneficiary is required to take RMDs during those first 9 years, in addition to having the full account withdrawn by the end of year 10. And in that case, those RMDs are still going to be based off of the beneficiary's life expectancy. So something to note that these regulations regarding if RMDs are required or not for these inherited IRAs under the new Secure Act rules, the IRS is even still really fine-tuning those regulations. So since some of these regulations only came out in 2022 or still coming out in 2023, there's safe harbors for individuals who inherited IRAs after 2020 but hadn't taken RMDs in those first couple of years. So if you didn't take that RMD under 2022 or 2023, because the IRS hadn't really even come out with those regulations yet at that point, then there's still no penalty for failing to do so. So just to be mindful of. So that's all I have to say about inherited inherited IRAs and the Secure Act today. If you have any more questions, please visit us at our website, which is kkc-law.com for more information.